getting ready for your ACCA Corporate and Business Law exam? Well, if you are, you absolutely need to get your head around the English legal system. So over the next few minutes, we're going to break down its core foundations, from where our laws even come from to how the courts put them into practice. This is the essential knowledge you'll need. Let's dive in.
We're going to take what I like to call a foundations-up approach. First, we'll start at the very bottom, with the bedrock, the sources of English law. Then, we'll look at the rulebook that makes sure everything stays consistent. From there, we'll climb the ladder of the court hierarchy, and we'll finish up by looking at a really important modern influence that shapes how all these parts work together today.
All right, let's get straight into it. Section 1, the bedrock. Before we can understand anything else, we have to ask a really basic question. It seems like such a simple question, doesn't it? But the answer isn't just one thing. It actually reveals two parallel engines that are constantly running, constantly shaping the law in England. Essentially, English law flows from two major sources: legislation and case law. You can think of it as law written down by Parliament on one hand versus law that's built up piece by piece by judges in court on the other. Let's tackle the first one.
First up is legislation, which you'll also hear called statute law. These are laws made directly by Parliament. And the key principle to get in your head here is parliamentary sovereignty. This means that an Act of Parliament is the highest, most powerful form of law in the land. It can make new laws, change old ones, get rid of them completely. Nothing can override it.
Now, on the other side of the coin, we have case law or common law. And this is fascinating because it's organic. It grows, it adapts over time. When a judge has to make a decision in a brand new type of case where there isn't an obvious statute, their judgment can actually become a new piece of law. It's law that's literally built from real-life arguments, adapting as our society changes. Okay, so hold on. If you have individual judges making law, what stops the whole system from just becoming a chaotic mess, right? How do you make sure the law is fair and predictable for everyone? Well, the answer is a very powerful rulebook that's been around for centuries. This whole system relies on one core principle, stare decisis. Now, don't worry about the Latin. It simply means to stand by things decided. This is the official name for the doctrine of binding precedent, and it's the glue that holds common law together. It ensures that similar cases get treated in a similar way. So, stand by things decided sounds good, right? It makes sense. But what does a judge actually do when a new case lands on their desk? How does this work in the real world? It's a very clear step-by-step process. First, a judge with a new case doesn't just invent a solution. Their job is to look backward, to find a precedent, a past case with similar facts that was decided by a higher court. Then, they have to figure out the exact legal reasoning for that past decision. And here's the most important part. They are then bound to apply that same reasoning to their current case. It's not optional. And that core legal reason has its own fancy Latin name, of course. It's called the ratio decidendi, literally, the reason for the decision. This is the golden thread in any judgment. It's not the judge's random thoughts. It is the specific legal principle that actually sets the binding precedent that all future courts have to follow. Now, you've heard me say higher courts a few times. That's because this whole system of precedent only works if there's a strict hierarchy, a ladder, if you will. This structure is what gives the whole thing its power, because it decides exactly whose decisions bind whom. In any system with rules and rankings, there has to be a final authority, right? A place where the buck stops. In the English legal system, who is sitting at the very top of this ladder? At the very, very top, we have the Supreme Court. It is the final court of appeal. Its decisions on points of law bind every single court below it in the entire country. Simple as that. They have the final word.
One step down that ladder is the Court of Appeal. Its decisions bind all the courts below it. And to keep things consistent, the Court of Appeal is also, for the most part, bound by its own past decisions.
Next, we've got the High Court. This court has a bit of a dual role. It hears some serious cases for the first time, but it also hears appeals from the lower courts. It's a really important middle rung on the ladder. It's bound by the two courts above it, while its own decisions bind all the courts below. And finally, at the very bottom, we have the courts, where most cases are actually heard. The Crown Court for criminal cases, and the county and magistrates' courts for everything else. Now, the absolutely critical thing to remember here is that these courts do not create precedent. They are only there to apply the precedents that have been set by the courts higher up the ladder. So, we have this ancient system of precedent and hierarchy, all chugging along. But what happens when a massive piece of modern law gets thrown into the works? Well, the Human Rights Act of 1998 was exactly that, a law that really changed how every court looked at every case. This didn't just come out of nowhere. The UK was actually one of the countries that helped write the European Convention on Human Rights way back in 1950. But for decades, you couldn't actually enforce those rights in a UK court. The Human Rights Act changed all that. It effectively brought those rights home, making them part of our own domestic law.
This quote you're seeing here, this is the absolute key takeaway from the Act. Section 3 puts a powerful new job on the shoulders of all courts. It forces judges to actively try and read every law in a way that is compatible with human rights.
So what does that mean in the real world? It means every judge, from a local magistrate all the way up to a Supreme Court justice, now has to look at laws through a human rights lens. It added this new, fundamental layer of interpretation to their job, and it influences how both legislation and case law are applied.
And that brings us to a final, really important idea. The English legal system is a constant balancing act. On one hand, you have the stability and certainty of precedent. On the other, you have the need for the law to adapt and change with the times. The Human Rights Act is a perfect example of this tension, and it makes you think, how does a system built on centuries of tradition continue to respond to the demands of the modern world?